For the purposes of today, I want to remind the committee and those with us and those watching at home, and I should remind everyone we are being broadcast on MPBN through the Capital Connection this morning, that the purpose of our inquiry today is to gather sufficient information to understand what really occurred and root causes and factors of what occurred in order to better assess several things towards informing the GOC's possible actions. Our scope is to further obtain information that was contained in and issues and concerns arising from OPEGA's Healthy Maine Partnerships FY13 Contracts and Funding Report in relation to Maine CDC's decisions to change the structure for the delivery and the funding for the Healthy Maine Partnerships, the process used and decisions made in selecting the lead HMP, and the maintenance of documentation supporting that effort. Specifically, we are interested to what extent DHHS's proposed actions on OPEGA's recommendations or other actions they've taken are sufficient to address issues and root causes, or whether DHHS should be required to take additional action, and if so, what those actions should seek to address. To what extent there may be a need for establishing statewide laws, policies, procedures, and guidance for situations where agencies are making selection and funding decisions among competing entities without an RFP, including what documentation should be generated in such situations. What specifically may be needed to be covered or addressed through the Records Retention Working Group the AG's office has suggested. To what extent this represents a situation where the intent of FOA was frustrated or actual violation of FOA occurred that potentially warrants putting additional clarification and penalties in the FOA or enhancing reporting avenues for potential FOA violations, and to what extent there are violations of expected ethics, accountability, and transparency that might warrant consideration of establishing or enhancing ethics policies and reporting avenues for potential ethics violations. Just want to start with that with the committee. That is the scope that we put together at our prior meetings for the purposes of today's inquiry. I just want to remind the committee of that and see if there were any questions related to that scope. Seeing none, thank you very much. We have received requests from 5 of the 6 people who we are having with us today to do this in executive session, to do the questioning. We need to take up that discussion and that question first as a committee so that we can move ahead and with the outlining of the procedures for the remainder of the day. We've specifically received requests from Sheila Pinette, Christine Zukas, Lisa Sakabason, Debra Wigand, and Andrew Finch for executive session. Director Ashcroft, I'm going to turn to you and ask you to lead off the discussion of this.
Sure. I'm Beth Ashcroft, Director of the Office of Program Evaluation and Government Accountability. Also here supporting you today is Linda Pistner, Chief Deputy of the Attorney General's Office, and Etta Connors, your committee clerk and my right-hand person. We thought it might be helpful, since the committee has not had an opportunity to really process this question together, for us to outline for you what it would mean if you go ahead with the executive session for the testimonies in terms of other implications for you as members and for the release of testimony that would be taken in executive session. So first of all, under the Legislative Investigating Committee statute, which is governing this proceeding, if a witness so requests, that witness's testimony must be taken in executive session unless otherwise decided by committee vote or action. So you will need to take a vote on that. Testimony that is taken in executive session cannot be released in any manner if that witness objects to the release of that testimony. So normally we will be, of course, doing an audio recording here. We are going to be preparing full written transcripts of the proceedings. That is the testimony that would not be able to be released. Right about that. It also would affect what the committee is able to deliberate in public after hearing such testimony. Any committee deliberations that involve discussion of testimony given in executive session would itself have to occur in executive session in order to maintain the confidentiality of that testimony. The committee should reach its conclusions in public session, and so the line between what can be discussed publicly and what cannot might be a little challenging, and we have legal advice available to us to navigate that should that become necessary. If the testimony is taken in executive session, then only the witness and their counsel, the committee members and staff, which includes myself and Linda Pistner, can be present. All others, including the media, would need to leave the room. And committee members and staff would need to know that they would need to keep any information they hear in executive session confidential. In other words, it wouldn't be something for discussion in any public arena or outside of this room. So those are the implications for taking testimony in executive session.
Thank you. Senator Craven.
Thank you, Madam Chair. I think that what caused a lot of this problem to begin with was a lack of transparency, and I would not favor going into executive session. Sorry. And so I would move not to go into.
I'm going to ask you to hold off on the motion, just because I have a specific motion need that relates to statute. But I appreciate the direction you're headed. But if you don't mind, I'm going to ask you to hold back on the motion just for a moment. Thank you, Senator Craven. Any other comments at this point? Yes, Senator Burns.
Thank you, Madam Chair. I've thought about this an awful lot since the issue came up and we decided that we were going to do this. And I think the first statement that the director made is indicative to me as to what we ought to do. And that's that when somebody requests this, the onus is on us as a committee to decide some compelling reason as to why we shouldn't go into executive session. And I think, from what I've learned here and what I want to learn here, the prudent thing for us to do is, if we really want to know, and everybody in this horseshoe wants to know who, what, when, and why, the prudent thing for us to do is to do this in executive session with that particular person that has been compelled to be here, and learn as much information as we can, and as a result of that, make our deliberations and come back with a final decision. To suggest that this is less than a transparent process, I think, is absurd. If you look around this horseshoe, we are equally represented by both parties in both chambers. And if we can't be trusted to make these types of deliberations, then we shouldn't have this committee to start with. These are sensitive issues involving a lot of good people. Some may or may not have done things wrong. Some may or may not have made errors without intending to do so. I don't know. But if we want to get to the bottom of this, we should do an executive session. And we don't want to be used as a forum to settle somebody's litigation. And that's what I feel that this is headed for. So I guess it's up to us to make that decision. Either we are to be trusted with the information that's put forth here and make appropriate deliberations, or we aren't. And we should disband this committee. Thank you.
Thank you, Senator Burns. Senator Cates.
Thank you, Madam Chair. I find myself in the uncomfortable position of disagreeing with my friend and colleague, Senator Burns. I think this really goes to the core of why this committee even exists, to ensure that we have transparency and accountability in government. And I think it would be beyond ironic if we decided to do our work in secret. And I think it would be wrong if the committee responsible for sunshine in government does its work in the dark. I understand what Senator Burns says, and that perhaps we could get better information from folks if we went into executive session. I don't particularly believe that myself, but that same argument could be used why court proceedings should be held in private, because maybe we'd be able to get to the truth more easily that way. But we don't do that. We don't allow court proceedings to be held in secret, and I don't think we should do our work that way here either. I've got great confidence that the people who are going to testify are going to give us truthful answers to these questions, no matter what the setting. And this committee, again, responsible for transparency, ought to be doing its work in public, and I will vote to not go into executive session. Thank you.
Thank you, Senator Cates. Senator Johnson.
Thank you, Madam Chair. I would largely agree with Senator Cates' assessment. I think that there is an important line between what we're trying to get to about the operation of state government and the questions relevant to the court case. And the council here today, for those who will be coming before us, are responsible for ensuring that questions we ask that might, in their opinion, jeopardize that court case, have an opportunity to not be answered. I think that's the protection, and that there is important matters about the operation of state government that we need to get to the bottom of, and we need to do so in a transparent manner if our work and the outcome of this is to be trusted by the people.
Thank you, Senator Johnson. Any other comments? Otherwise, yes, Representative Davis, excuse me. Excuse me. Still over in Burns. Representative Davis.
Your excuse.
Thank you.
Thank you. I don't see this as being compared to a court case. I see this more as a deposition. And depositions almost always are handled in private. And I agree with Senator Burns. I think we need to get to the bottom of this and have it done. And I think that the people have asked for executive session. They have been subpoenaed. They aren't coming here willingly. Well, maybe they are, but they didn't have any choice in the matter. And I think that we should, I'll vote for executive session. Thank you.
Thank you, Representative Davis. Any other comments? Yes, Representative Cotta.
Thank you, Madam Chair. I appreciate the positions and the opinions of others on the committee. The issue that bothers me, and we've all talked about it, is timing. There is an ongoing, litigation, and the matter that Senator Burns bring up, that being trusted, and as Senator Cates mentioned, as far as these should be open. I agree with both of those positions, but it's an issue of timing. And I think if we are to go forward, we should do so in executive session, or wait until the litigation is completed.
Thank you, and I would just add, I think there's, appreciate the comments of committee members, and certainly this will set the tone for the day and how we're going to move ahead with our procedures. The procedures are different. And it's not lost on me that where we are today as a committee is a new space for the Government Oversight Committee. It's really the first time we've been at this intersection. I think we are also at a precedent-setting moment. And it is a dangerous precedent to set, in my opinion, that when litigation that is external to us is filed and is ongoing, that somehow the work and obligation of the Government Oversight Committee should be put on hold or defer to that, when really we have a distinct and separate and very clearly articulated purpose around transparency and accountability and oversight in government and accountability. And I think that, to me, is at the heart of my personal opinion that we should keep today's discussions in public. I think that is the right place for us to start. And I didn't want to leave any question before we got to a motion. So now I'll turn to Representative Kruger and ask you to make the motion.
Thank you, Madam Chair. I've thought about this, and I'm certainly sensitive to the issues that Senator Burns and Representative Davis have mentioned, but I think I'm going to go the other way in favor of sunlight. And in accordance with Title III, Section 427 I will move that the committee take the testimony of Debra Wigand, Andrew Finch, Lisa Sockabasin, Sheila Pinette, and Christine Zukas in public session rather than executive session.
It's a motion and it's a second. Is there any additional discussion? Yes, Representative Boland. Welcome.
Thank you. Madam Chair, not to further complicate the issue here, but is it possible to have public session, but if there were one particular kind of a question that it seemed was very important to answer, is it possible to go into executive session on a, one at a time sort of consideration?
Yes, it certainly is possible that if at some point the committee would like to do some of our work in executive session. We also, and I'll bring this up, go over this in a little bit, that we also have the ability to go into executive session with our legal counsel as a committee just for the purposes of getting legal advice. And so certainly procedurally we have all avenues available to us over the course of today. Yeah. Any other discussion?
Hi, Eric Buell. Is it possible for me to address the committee after this motion? I don't want to step on your toes procedurally, but I just don't want to miss the opportunity to address it.
There will be a lot of, that we're having, the people at home can't hear you. So we have had, I bet you are happy to use the microphone. And I will ask those in attendance today to please respect the role of the committee and understand that everyone will have an opportunity, every one of the people who's been subpoenaed today will have an opportunity to come before the committee with their counsel, and will have the opportunity to engage with the committee. Right now the committee is in the posture of needing to take a vote on the question of executive session and whether or not to be in public. Yes, Senator Burns.
Madam Chair, I guess my question would be if this gentleman has some legal advice, and I know we have counsel, but we have counsel here that would hear that, and I guess I would like to hear what the advice is, if he has that. If it has to do with the testimony, then I would agree with you. If he wants to offer a slant before we take a vote on this executive session, then I think we should hear from him. He has a stake in this.
We have a lot of attorneys in the room today who have very serious obligations to their clients, and I respect every single one of them greatly and the responsibilities that they have.